Ladies and gentlemen, welcome and thank you for joining today's conference. Please note that all phone lines will be muted for the duration of today's call. You are welcome to submit written questions during the presentation, and they will be addressed during Q&A. Instructions on how to submit a question will be sent out shortly after we begin. With that, I'll turn the call over to Mariana Pardo, Director of the HUBZone program. Please go ahead.
Thank you. My name is Mariana Pardo. I'm the Director of the HUBZone program, and I welcome you to the first webinar regarding contracting, HUBZone contracting. I'm joined by my colleague, Mark Hagedorn. He's an attorney advisor with the Office of General Counsel. And we here in this slide, we're giving you the links to the particular citations in the regulations so that you can refer back and understand a little bit more what governing regulations apply. These are the items that we're going to be covering today, a brief program overview, and then we're going to jump in right into the HUBZone contracting, the set-aside, the sole source, set-asides of orders, applying the price evaluation preference in full and open competition, and the limitations on the subcontracting and non-manufacturer rule. It's important to remember that the HUBZone program the mission of the HUBZone program is to work with firms that are located in the most impoverished areas of the country. And as they get certified, they will have an opportunity to bid on contracts that are limited to HUBZone certified firms. It's important to remember that the firms must be certified by SBA in order to take advantage of the program. So if a firm is located in a HUBZone and perhaps their business card says the firm ABC is in a HUBZone, that does not mean that the firm is certified as a HUBZone company. They have to come in to SBA, apply, and once they are approved, they're displayed in the dynamic small business search, which is a list that contains the qualified businesses, and you have there a link to that site. Only those firms that are in this list are eligible to receive contracting preferences and awards under the program. These are the different types of HUBZone contracts. Sole source, and we're going to be covering all this, 100% HUBZone set-asides as well as partial set-asides. There's a price evaluation preference that is applied when a HUBZone firm competes in full and open, and there are reserves for HUBZone small business as under the multiple award contracts, and orders set-asides that are against these multiple award contracts when the multiple award contract was awarded in full and open competition. When a company submits an initial offer on a contract, on a specific HUBZone contract, the firm is certifying to the contracting officer that they are in the list. So that's why it's so important to first apply for the certification in order for the firm to bid on these opportunities. So they're certifying to the federal government, to the contracting officer, that they are on the list. And there has been no material change that affects their eligibility on the program, that they're small, and if they obtain this contract, if they're awarded this contract, that they will attempt to maintain the requirements, the required percentage of employees that are residing in HUBZone, which is a minimum of 35%. I want to mention something on the attempt to maintain before I move to the next slide. When a firm gets an award on a HUBZone contract, the firm may fall below this residency requirement as long as they're making reasonable attempts to maintain it. And if SBA is conducting an audit, a program exam, let's say, the company will have to submit evidence of what are their efforts to recruit more HUBZone employees from the different areas. In order to be eligible for a HUBZone contract, the firm has to be eligible, they have to be in compliance and in the list at the time they're submitting the offer and at the time of award. A HUBZone small business can form a joint venture with any other small business, or if they're part of an SBA-approved mentor protege, the All Small Mentor Protege program, for example, if the HUBZone firm is in that program, they can form a joint venture with that mentor because it was approved, that relationship was approved by SBA. So that joint venture, the HUBZone joint venture, will be considered to be a HUBZone firm, a HUBZone joint venture, in order to submit a contract, an offer to a HUBZone solicitation. The joint venture itself is not certified as a qualified small business concern. So the joint venture will be registering in SAM.gov as a joint venture, as a HUBZone joint venture, and it's a self-certification. It could be evaluated afterwards by SBA, and we have another webinar that we're going to be talking about joint ventures, and we also have another webinar later on that will be talking about protests and appeals in connection with contracts. So if you're interested in this topic, I encourage you to participate to those two webinars coming up. This is the list. This is the Dynamic Small Business Search. It's a screenshot of the Dynamic Small Business Search. I encourage you, if you're not already listed there, to make sure that you provide a profile that is a healthy profile. Put as much information about the company as possible so people can find you. You can amend this profile by adding keywords so that the contracting officers can find you. As you see on the top, says there quick market search that is used by the contracting officers in order to find companies. And you can use it yourself to see how it functions. Just go in as an external party and see if you can find your firm. This is the way that how the HUBZone certification would be displayed. There are different data elements in the Dynamic Small Business Search that indicates whether a firm is a HUBZone certified concern or not. As you see in this screenshot, is midway down in the profile, this firm is certified, and it shows there the HUBZone certification date. Now, this is an example of a firm that was certified but is no longer certified, so it has been decertified either by SBA or voluntarily by the firm. So it will show that the time frames that the firm was certified. And the last slide here, it indicates a firm that was never certified by SBA because it shows that certification date being not applicable. Now I'm going to move over to the contracting piece, and Mark will take over now.
Thank you, Mariana. So I'm going to talk a little bit more about contracting with the federal government as a HUBZone firm. So we're going to first start by talking about the relationship among our small business programs here at SBA, and that can be found in the Federal Acquisition Regulation at that citation if you're interested in learning a little bit more about that. So in addition to our size standards program here at SBA, we have 4 small business socioeconomic set-aside programs, and those include the 8A program for socially and economically disadvantaged individuals, the HUBZone program for opportunity and development in economically distressed areas and communities. We have our Service Disabled Veteran-Owned, or SDVO, small business program, and finally we have our Women-Owned Small Business program, also known as our WASB program. We just want to emphasize today that there is no order of precedence among these programs, or in other words, there is parity between these programs. And we just want to emphasize that because several years ago, the HUBZone provisions of the Small Business Act were worded in a way that suggested that HUBZone might take priority or precedence over the other socioeconomic set-aside programs. That language has been revised to now affirmatively state that all programs are equal. And so when we talk to acquisition staff, we encourage them to look at the results of their market research and their results in how they're doing on meeting agency small business goals in determining which program that we just discussed would be best appropriate for their acquisition in question. So now we're going to move specifically into HUBZone set-aside. We're going to talk a little bit about HUBZones and parity. And specifically, we're going to talk about how a contract's value can impact small business considerations when a contracting officer is deciding which program to use or how to award that contract. So for acquisitions that are valued between the micro purchase threshold, which is currently valued in the FAR at $3,500, but has been revised in the 2018 National Defense Authorization Act to $10,000. Between that threshold and the simplified acquisition threshold, which is currently $150,000 in the FAR, but has been up to $250,000 in the NDAA, those acquisitions are automatically reserved for small businesses. However, the contracting officer can choose any of the 5 programs that we just discussed on the last slide. So that would be a small business set-aside, an 8A set-aside, a HUBZone set-aside, an SBVO set-aside, or a WASB set-aside. Again, there is parity among these programs, no preference. If the acquisition is valued at a value above the simplified acquisition threshold, the agency must first consider making the award as a socioeconomic set-aside or a socioeconomic sole source award before considering the award for a small business set-aside. So again, there's no preference between the socioeconomic set-aside programs or the sole source awards, but the contracting officer would have to first consider an award to those entities before considering a total small business set-aside. There is one exception that we do want to highlight today, and that's what we generally call the once 8A, always 8A rule. And that means that if a contract has been accepted into the 8A program by SBA, any follow-on requirement must stay within the 8A program unless the contract is released from the program by SBA's Associate Administrator for Business Development. So that's the only exception to that rule. So now we're going to talk specifically about HUBZone set-aside and sole source awards and the procedures. And these are set forth in our regulations, SBA regulations at Title 13 of the Code of Federal Regulations, Part 126, and also in FAR Part 19. So again, if an acquisition is valued below the simplified acquisition threshold, the agency may award as a HUBZone set-aside, but it could also go as a small business set-aside, 8A set-aside, WASB set-aside, or SBVO set-aside. If the acquisition is valued above the simplified acquisition threshold, the contracting officer or the agency must first consider whether a HUBZone set-aside or a HUBZone sole source award is appropriate before considering a total small business set-aside. However, before the contracting officer can award a HUBZone set-aside contract, the contract must satisfy what we call here at SBA the rule of 2. And that means that the contracting officer, after performing market research, must have a reasonable expectation that offers will be received from at least 2 HUBZone small business concerns, and award can be made at fair market price. And that's actually the requirement for any set-aside program, HUBZone, 8A, WASB, or SBVO. So in this next slide, we're going to talk about an instance where the agency has conducted market research and determined that a HUBZone small business set-aside was appropriate because the rule of 2 was satisfied for HUBZone concerns. So in that case, if the contract is solicited and only one acceptable offer is received from a HUBZone small business concern, our regulations and the FAR state that the agency should make award to that firm. If no acceptable offers are received from a HUBZone small business concern, then the FAR states that the CO should withdraw the HUBZone set-aside and re-solicit the requirement as a small business set-aside as appropriate. And again, we tell contracting acquisition staff across the country to look at the results of their market research as well as their progress in meeting small business contracting goals. We're going to move next. We just finished talking about HUBZone set-asides. We're going to move just quickly and talk about HUBZone sole source awards. So there is sole source award authority in the Small Business Act, and there are regulations in the Federal Acquisition Regulation and SBA's regulations implementing that statutory authority. So again, we kind of discussed the order of when a HUBZone sole source award would be appropriate. A contracting officer may consider a HUBZone sole source award after considering a HUBZone set-aside, but before considering a total small business set-aside award if the contracting officer does not expect to receive offers from at least 2 HUBZone small business concerns, or stated otherwise, the rule of 2 is not met on the acquisition. The value of the contract exceeds the simplified acquisition threshold. Again, that's currently $150,000 in the FAR, which will be changing soon to $250,000. It has to be above that threshold, but it cannot exceed the sole source ceiling. And that is actually dependent on the type of contract it is. For contracts that are assigned to manufacturing NAICS codes, that is $7 million. For all other requirements, including services contracts, that is $4 million. In addition, HUBZone sole source awards are also subject to the once 8A, always 8A rule. So if a contract has been accepted into the 8A program, any follow-on contract to that would have to go 8A unless it was released by the program, and only then could it be made as a HUBZone sole source award. The last two requirements are actually requirements that have to be met for any contract with the federal government, and that is that the HUBZone sole source awardee has to be determined to be a responsible contractor with respect to performance, and award must be made at a fair and reasonable price. The last note on this slide is that we just want to note that SBA, the administrator, does have the right to appeal a contracting officer's decision not to make a HUBZone sole source award. This is a discretionary authority that is not exercised very much, but we just like to let folks know out there that it is available. So now we've talked about HUBZone set-aside awards and HUBZone sole source awards, which are two of the primary HUBZone contracts that we see come through this office, and we just wanted to highlight a couple, I guess, best practices that you can do as HUBZone concerns that would increase the number of HUBZone contracting opportunities. As Mariana mentioned earlier, it's very important to market your firm's capabilities on the SBA Dynamic Small Business Search, or DSBS. And as Mariana mentioned, this is where a lot of contracting officers start when they're doing their market research. And so they will narrow it down by keyword or NAICS code, and they will be looking for HUBZone firms in their area that can perform the work. So by keeping that information up to date and highlighting your capabilities, you're more likely to get noticed when the agency's conducting its market research. In addition, we encourage HUBZone firms to respond to the government's sources sought notices and requests for information. These are pre-solicitation requests for information that will ultimately inform the market research efforts conducted by the agencies to let them know which HUBZones are out there and who can perform the work. So it's very important, if you see a sources sought or request for information, to make sure you respond to that so that they know it's out there, and that kind of documentation will justify a HUBZone set-aside or sole source. The next point we want to emphasize is we encourage you to participate in any agency outreach events that are specifically targeted to HUBZone vendors. So many of you may be familiar with DoD's Industry Days. Agencies a lot of the times will have matchmaking events. And we want to highlight this because when we reached out to agencies that have been consistently meeting their HUBZone goals, one of the themes we saw over and over again is that they are making relationships with HUBZone vendors that come in and create a personal relationship. And so by going to these matchmaking events and these industry days, you're getting your name out there, you're marketing your capabilities, and these agencies are going to be more likely to reach out to you when they're, they'll think about you when they're soliciting information about contracts. Next, we want to encourage that you engage your servicing procurement center representative and the agency's small business professionals to build relationships and further inform the agency's market research efforts. We'll talk about this a little bit later in the presentation and also in some of our other webinars, but procurement center representatives are your advocates at these agencies, and so they will review potential solicitations to see if a HUBZone set-aside or HUBZone sole source award would be appropriate for that particular contract. So by reaching out to them to build a relationship and also inform them of your capabilities, that will get documented in the market research file and will justify, hopefully, a HUBZone set-aside or sole source award. So please don't be shy. The next point we want to emphasize is to consider participating in the All Small Mentor Protege program or obtain additional small business certifications, including 8A or WASB certifications. We'll talk about the All Small Mentor Protege program in another webinar, but kind of as Mariana already touched on it, This is a program that's designed to provide business development assistance to the small business protege, and HUBZone firms are absolutely qualified and encouraged to participate in that program. One of the big benefits is also that HUBZone firms can joint venture with their mentor and enjoy an exception to affiliation. So you can leverage your mentor, even a large business mentor, you can leverage their past experience or their bonding, or their capabilities when you're bidding on a HUBZone contract. In addition, additional certifications are important because, for goaling purposes, contracting officers get credit for the different certifications that they are making awards to. So if you are a HUBZone firm that is also 8A certified or is also a women-owned small business, an award to you counts as credit towards all three of those categories. So it definitely makes you more attractive to the agencies. The last point I do want to say, though, but please don't rely exclusively on your small business certifications. We hear time and time again from the procurement center representatives as well as the agencies that, the HUBZone firms that are putting out information need to demonstrate to the government how your capabilities will ultimately fulfill the customer's buying requirement. So we're going to move and talk specifically a little bit about set-asides of orders. And we want to highlight this because recent statutory and regulatory changes now give agencies discretionary authority to set aside orders that are placed against a multiple award contract that's awarded in full and open competition without any additional justification. Again, this is a discretionary authority. It's not mandatory, but we're out there educating agencies that it's available. And if you are a scheduled contract holder, you can also educate the agencies that are using that vehicle to let them know that this authority is out there. Analogous authority also lets agencies set aside part of a multiple award contract that was awarded in full and open competition. And this would be appropriate where the acquisition can be broken down into smaller portions, generally by contract line item number or CLIN number, or the special item number. And in addition, this would be appropriate where the rule of two is not met for the entire acquisition, or in other words, two or more concerns could not, the contracting officer cannot reasonably expect two or more HUBZone concerns to bid on the entire contract. However, the rule of two will be met for one of those smaller portions that we just discussed. This authority also lets contracting officers reserve one or more contract awards for a HUBZone small business concern when that contract is being awarded against a multiple award contract in full and open competition. This would be appropriate where a full or total small business set-aside would not be appropriate because the rule of two is not met on the entire acquisition, and a partial HUBZone set-aside wouldn't be appropriate because the contract, at least at the pre-solicitation stage, was not able to be broken down into discrete portions. The contracting officer may nevertheless reserve part of that contract for small business participation and specifically HUBZone participation, and then compete orders issued against that multiple award contract against small businesses in HUBZones. In the next slide, we just want to emphasize that when you're out discussing this with your colleagues or with the agencies, please note that orders that are issued against a multiple award contract in full and open competition that are reserved for small businesses, including HUBZones, are subject to FAR Part 19. And for our purposes, that means that the HUBZone joint venture requirements apply, the HUBZone limitations on subcontracting apply, and the HUBZone Nonmanufacturer Rule applies. So just please be aware that any order issued to a small business would implicate those requirements. Next, we're going to talk about the HUBZone price evaluation preference. This is a preference that is unique to the HUBZone program, and it provides a comparative advantage to HUBZone firms that are bidding on acquisitions conducted in full and open competition. And so today we're going to go through and discuss the preference generally and then move into some examples so that you can confidently bid and hopefully win contracts in full and open competition as a HUBZone firm. The most most important thing to remember is that the HUBZone price evaluation preference is only used in acquisitions that are conducted in full and open competition. And this includes any non-reserved or non-set-aside portion of a contract that was awarded in full and open competition. However, the price evaluation preference is not used when price is not a selection factor, and that's most commonly seen for architecture or engineering acquisitions, or where all fair and reasonable offers are accepted. The most common example of this would be a GSA schedule contract. We're going to move into application of the price evaluation preference. And we're going to highlight the difference between the application as it's enumerated in the Federal Acquisition Regulation, and then we're going to discuss how SBA regulations discuss the application of the price evaluation preference. I just want to note that under either approach, the end result is the same. And so it shouldn't matter how the price evaluation preference is ultimately applied. So we just want to highlight the differences because the contracting officers will likely use what's set forth in the FAR, but if they do choose to follow SBA regulations and apply it in that manner, it's important to know the nuances and to understand how it is. So the FAR states that the contracting officer shall give offers from HUBZone small business concerns a price evaluation preference by adding a 10% price factor to all offers except offers from HUBZone small business concerns that have not waived the price evaluation preference or otherwise successful offers from small business concerns. For LPTA procurements or lowest price technically acceptable procurements, this is generally pretty straightforward. You just take whatever the bidding prices are and you add a factor of 10% to all of the offers except the two that we just discussed. It's not trickier with best value procurements. It just requires an extra step. So for best value procurements, the contracting officer would have to do an initial trade-off analysis to determine ultimately who is the apparent successful offeror, and then the price evaluation preference would be applied in a manner as set forth above. The first point says that a factor of 10% is added to offers from HUBZone small business concerns that have not waived the price evaluation preference. And so we just want to explain maybe why a HUBZone concern would waive the price evaluation preference if it's offering on a procurement that's conducted in full and open competition. And the reason for that is that if a firm is attempting to benefit from the price evaluation preference, that contract, which was formerly conducted in full and open competition, becomes a HUBZone contract, and that means that FAR Part 19 and SBA regulations apply. And so the firm that benefits from the price evaluation preference would have to comply with the HUBZone limitations of subcontracting and the HUBZone Nonmanufacturer Rule. So now we're going to move in and discuss the application of the price evaluation preference as it's specified in the Small Business Act and SBA's implementing regulations. And these regulations state that the contracting officer must deem the price offered by a HUBZone small business concern to be lower than the otherwise successful offer of a large business if the price offered by the HUBZone is not more than 10% higher than the price offered by the apparent successful large offeror. So SBA's regulations have broken it down into 3 easy steps, and we hope these are helpful for your understanding of the price evaluation preference. So step 1 is to determine that a large business is in fact the lowest responsible offeror, or is the otherwise successful offeror under the contract. Again, as we discussed, for best value procurements, the contracting officer will perform an initial trade-off analysis to determine that in fact a large business is the apparent successful offeror. Step 2 is you're going to add a factor of 10% to the otherwise apparent successful large offeror. Step 3, compare the factored offer of the large business to the price offered by the most successful HUBZone firm that has not waived the price evaluation preference. Our regulations state that awards shall be made to the HUBZone small business concern where, after considering the price evaluation adjustment, the price offered by the HUBZone small business concern is equal to or lower than the price offered by the otherwise successful large business. Or in the case of a best value procurement, award would be made to the HUBZone concern where, after considering the price evaluation preference, the HUBZone firm offers an equal or better value than the large business offeror. So now we're going to move into the price evaluation preference examples that I referenced, and I'm just going to read through the numbers so everyone can follow along at home if you're not watching the screen. In this instance, we have a HUBZone firm that offered at $113. We have a HUBZone firm that has waived the price evaluation preference, offering at $108. We have a small business that is offered at $103, and we have a large business that is offered at $100. So before the price evaluation preference is applied, the large business is the apparent successful offeror because it's the lowest responsible offeror under the contract. So if we're going to apply the price evaluation preference under the FAR, you can see that the HUBZone firm's offer doesn't change. The HUBZone firm that has waived the price evaluation preference, that price is factored by 10%. The offer of the small business is factored by 10%. And the offer of the apparent successful large business is factored by 10%. So you can see that the large business under the FAR approach is still lower than the HUBZone firm that has not waived the price evaluation preference at $113. So under the FAR rules, it does not benefit the HUBZone firm because the large business is still the lowest offeror under the contract. Under SBA's application, you can see that the large business is the apparent successful offeror. So we compare that price factored by 10% against the price offered by the most successful HUBZone firm that has not waived the price evaluation preference. In this case, the same result applies here. Because the HUBZone firm is higher than the large business offeror after the price evaluation preference, the price evaluation preference does not benefit the HUBZone firm. In the next example, the HUBZone firm offered at $100. The HUBZone firm that has waived the price evaluation preference has offered in at $99. The small business has offered $97, and the large business has offered at $95. So again, before the price evaluation preference is applied, the large business is the apparent successful offeror because it is the lowest responsible offeror under the contract. If we apply it under the FAR rules, the HUBZone offeror that has not waived the preference stays at 100. The HUBZone firm that has waived the preference is factored by 10% to 108.9. The small business offer is factored by 10% to 106.7. And the large business offer is factored by 10% to 104.5. So in this case, the HUBZone firm's offer is lower than the apparent successful large offeror. So it is the lowest responsible offeror now, and contract award will be made to the HUBZone firm. Or in other words, the price evaluation preference has benefited the HUBZone firm. Under SBA's application, we saw that the large offeror is the apparent successful offeror, so we factor that by 10% and compare that offer to the most successful HUBZone firm that has not waived the price evaluation preference. In this case, it's the same result. The HUBZone firm is at $100 and the large business is at $104. So in this case, the price evaluation preference does benefit the HUBZone concern, and award should be made to that firm, the HUBZone firm. Just a quick note, we already covered it earlier in the presentation, but again, if there is a tie at the end of the application of the price evaluation preference, that tie goes to the HUBZone small business concern. The last example here that we're going to discuss, the HUBZone firm has offered at $100. The HUBZone firm that has waived the price evaluation preference has offered at $99. The small business has offered at $95, and the large business has offered at $97. So under the FAR's application of the price evaluation preference, the small business offeror is the apparent successful offeror. So in this case, we do not factor the small business's offer by a factor of 10%. So once you've done the numbers under the FAR approach, the HUBZone has offered at $100. The HUBZone firm that has waived the preference has been factored by 10% to 108.9. The small business's offer is not factored. It stays the same at 95. And the large business's offer is factored at 10% to 106.7. So in this case, the small business offer is still lower than the HUBZone offer, and therefore the price evaluation preference does not benefit the HUBZone concern. SBA's approach is a little bit more straightforward in this case, and it's just simply where a small business is the apparent successful offeror under the contract, the price evaluation preference is not applied, and it cannot benefit a HUBZone small business concern. So now we're going to move into the limitations on subcontracting and the non-manufacturer rules that are applicable to the HUBZone program. And we want to emphasize here that just recently SBA has revised its limitations on subcontracting rule and the non-manufacturer rule for the HUBZone program. However, these rules have not been implemented in the FAR. But it's important to know both versions because until the FAR has been revised to catch up to SBA regulations, agencies may use either one. And while we are counseling agencies to use SBA's rule, sometimes the general presumption is to always refer to the FAR. So please be familiar with both, and you can always ask the agency which rules they're going to apply in connection with a particular acquisition so you can have that information going forward when you're bidding on a contract. So we're going to start with the limitations on subcontracting. The new limitations on subcontracting rule shifts what was previously a prime contractor's performance of work requirements to limitations on the amount a prime contractor can subcontract to non-similarly situated entities. And SBA's regulations, and for our purposes, define a similarly situated entity as a contractor that qualifies for the same small business certification as the prime contractor. So for a HUBZone contract, a similarly situated entity would be any other subcontractor that has qualified HUBZone status. So what the limitations on subcontracting provide is that for contracts that are assigned to services NAICS code, except construction, the HUBZone small business concern prime contractor can spend no more than 50% of the value of the prime contract on subcontractors that are not HUBZone small business concerns. Or as it's listed in SBA regulations, they may not spend more than 50% of the value of the prime contract on entities that are not similarly situated. This is a little bit different from the FAR rules, which are still currently in place, which state that the small business contractor can spend at least, it must spend at least 50% of the contract, the cost of the contract, on the small business concerns employees. So just highlight the distinction there. The limitations on subcontracting is a little bit more forgiving in terms of how much a prime contractor can sub out. For supplies, SBA's new rule states that the HUBZone prime contractor may spend no more than 50% of the value of the prime contract on subcontracts that are not HUBZone small business concerns. Again, the FAR is a little bit different. It says that the HUBZone prime contractor must spend at least 50% of the manufacturing costs. For general construction, SBA's rule states that the HUBZone prime contractor may spend no more than 85% of the value of the prime contract on similarly situated entities. The FAR provision is a little bit different. It says that the HUBZone prime contractor must spend at least 15% of the contract of the cost of contract performance incurred on its own personnel. And then for specialty trade construction, the limitations of subcontracting rule in SBA's current rule states that the HUBZone prime contractor may spend no more than 75% of the value of the prime contract on subcontractors that are not similarly situated, again, HUBZone firms. For the FAR, this rule states that the HUBZone prime contractor must spend at least 25% of the cost of the contract performance incurred for personnel on its own staff. So it's a little bit confusing, but we just want to emphasize that the rules are a little bit different. So please look at what FAR clauses are in the solicitation and always ask the contracting officer which rule will be applied if there's any question. We're going to next move into the non-manufacturer rule. Again, this new rule, it's now in SBA regulations. It's been there since 2016, but the FAR provision is still forthcoming. So again, please note both rules and and know which one would apply to you in connection with each solicitation. So under SBA's new non-manufacturer rule, a HUBZone small business concern may submit an offer for supplies as a non-manufacturer if it meets the requirements of the non-manufacturer rule set forth in SBA regulations at Part 121. And those four big requirements are that the HUBZone firm qualifying as a non-manufacturer cannot exceed 500 employees. It must be primarily engaged in wholesale or retail. It must take possession of the goods in accordance with industry customs, and it must supply the end item of a small business manufacturer. So this is a little bit different from SBA's former rule and what is currently in the FAR, which states that a HUBZone prime contractor may submit an offer as a non-manufacturer if it meets those requirements that I just listed, except the last one is a little bit different in that the HUBZone firm can only qualify as a non-manufacturer if it's supplying the end item of another HUBZone firm. So SBA's new rule eliminated this requirement that the manufacturer also be a HUBZone small business concern. But note, for FAR purposes, if that rule is being applied, a prime HUBZone contractor can only qualify as a non-manufacturer if it's supplying the end item of another HUBZone small business concern. In addition, SBA's new rules permit a contracting officer to request an individual waiver of the non-manufacturer rule for a HUBZone contract, and this would be an instance where the contracting officer has reviewed market research and determined that no small business could reasonably be expected to actually manufacture the goods that are being procured. And so if that's the case, a contracting officer can now, under SBA's new rule, request an individual waiver. In addition, class waivers now apply to HUBZone contracts. And this is where any entity, including contracting officers, businesses, organizations, they reach out to SBA and provide market research and other data that indicate that no small business can reasonably be expected to provide a certain class of goods. And if SBA agrees with that, then SBA will issue what's known as a class waiver, and these class waivers are actually set forth on SBA's website. You can access them at any time to see which classes by NAICS code have been exempted from the non-manufacturer rule. But please note that these are in the new rule. They are not in SBA's former rule, and they are not in the current FAR rule. Under the current FAR rule, individual waivers of the non-manufacturer rule are not applicable to HUBZone contracts. So a contracting officer cannot request an individual waiver if it's soliciting the requirement as a HUBZone set-aside or if it's doing it as a HUBZone sole source award. And that also applies to a contract that's being conducted in full and open competition where the price evaluation preference benefits a HUBZone firm. In addition, class waivers were not applicable to HUBZone contracts under SBA's former rule and the current FAR rule. So please just note those three distinctions between SBA's current rule and what's also in the FAR currently. I just looked at the open FAR cases within the last week, and the FAR Council does have workable rules that are probably going to be promulgated in the next couple months, but please just note that in the interim, contracting officers might apply the FAR rule. It's important to note that you as the HUBZone firm are responsible for complying with the non-manufacturer rule. So although the contracting officer is the only entity, the only individual who can request a individual waiver under the non-manufacturer rule for a HUBZone contract, you as the HUBZone firm are responsible for compliance. We just want to note down there at the bottom that the HUBZone non-manufacturer rule is not applicable to HUBZone contracts at or below $25,000. For contracts valued at this amount or lower, a small business prime contractor can qualify as a HUBZone non-manufacturer as long as it provides the end item of any domestic manufacturer. And the item has to be produced in the United States. And last thing is that Mariana and I are more than happy to speak with acquisition staff if they have questions about the application of SBA's new HUBZone non-manufacturer rule. So if they are interested in applying SBA's rule before the FAR catches up with SBA regulations and they have some questions about it, please invite them to reach out to Mariana or myself, and we can explain the rule for them. Lastly, we're just going to talk about compliance with the limitations on subcontracting, and the HUBZone Nonmanufacturer Rule. Again, we kind of already went over it just a little bit, but the HUBZone limitations on subcontracting and the non-manufacturer rule apply to any HUBZone contract, and that includes a HUBZone set-aside, a partial HUBZone set-aside, a HUBZone sole source award, a HUBZone reserve, orders that are placed against a multiple award contract in full and open competition that are set aside exclusively for HUBZone firms, and then also awards that are made in full and open competition after the HUBZone price evaluation preference is applied. On any of those contracts, a HUBZone awardee is required to comply with the HUBZone limitations of subcontracting and the non-manufacturer rule. And the compliance period for that is a little bit different based on what kind of contract it is, but the general rule is that for a full or partial set-aside, the compliance period is the base term of the contract, and then each subsequent period of performance that's exercised as an option. However, the contracting officer always retains the discretion to require that the HUBZone firm meet the limitations of subcontracting or the non-manufacturer rule in connection with each order that's placed against that set-aside contract. If it's an order that is set aside in full and open competition, and this would, again, be a situation where a contract is awarded as a multiple award contract in full and open competition, but then an order is set aside exclusively for HUBZone concerns, the compliance period for that order would be just the term of the order.
Thank you, Mark. In here, the last few slides that we have, we want to give you resources that you can continue utilizing. These are resources free of charge, obviously. Your taxes are already covering all these costs. So there's local assistance. This is a tab that is available at the SBA.gov. By putting your zip code and a particular distance from your zip code, you can locate district offices, small business development centers, procurement technical assistance centers, etc. You're welcome to reach out to them, interview the counselors, find out which ones are best positioned to help you at whatever stage the business happens to be at. The HUBZone program also has office hours every Tuesday and Thursdays from 2 to 3 p.m. Eastern Standard Time. The calling number is available at the SBA website. Don't save the access code because periodically we need to change it to mitigate hacking on that. And we also have a mailbox, HUBZone@SBA.gov, to answer any other questions that you may have. The other contacts for contracting, obviously, are each federal office has small businesses office for small business utilization, so there's small business counselors in each of the federal offices that we encourage you to find them and introduce yourself, meet with them, talk about what your qualifications are, more important, what is coming up in that agency. Oftentimes they have the forecast available there for you to take a look at. As Mark mentioned earlier, the procurement center representatives, we're giving you a link to find them there. That's another excellent resource. And the district offices are available through that local assistance link that we provided earlier. In here we have additional information about what Mark was talking about, the non-manufacturing rule and class waivers that you can familiarize yourself a little bit more. I believe it has some lists there that tells you which ones SBA has already granted waivers to. And the program office, for additional information about the non-manufacturer rule, you have the email there that you can submit a waiver request or questions that you may have. I believe that that's the last slide. So thank you so much for participating in this webinar. And in about a month or so, it will be uploaded into the SBA YouTube channel, and we will be linking to that channel from our website too. Thank you so much.
Thank you to our speakers, and thank you all in the audience for joining us today. This conference is now concluded. You may now disconnect.